Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Our first case for argument this morning is Unite Here against Magnificent Mile Hotel Management. Mr. Gesvitz.
Thank you. Good morning, Your Honors. May it please the Court, I'm Irvin Geswitz and I represent the defendant appellant, Magnificent Mile Hotel Management, LLC. The lower court here erred in two ways. First, there was a bona fide dispute between the hotel and the union over the fairness of the way in which the arbitrator had been selected for a grievance, which led to impasse. Section 5 of the Federal Arbitration Act provides that where there is such an impasse, the role of the court is to break the logjam by appointing an arbitrator. The district judge refused to do so and instead ruled that the hotel had to proceed before the arbitrator whose appointment it had contested. That was error. The second error was when the lower court affirmed the disputed arbitrator's award. The case was a layup. The hotel had a zero-tolerance policy for any kind of violence or physical intimidation or for carrying weapons in the workplace. A security video captured the incident. It clearly showed the grievant pulling out a knife, snapping it by his wrist to open it, and holding it open as he approached an elderly female coworker. The arbitrator nonetheless overturned the discharge. Why? Because the employee had what he called a goofy grin on his face, so he had no intent to harm.
Mr. Kessler, I'm going to stop you and ask, because, you know, of course, under your theory, what would stop a party from waiting to see which arbitrator is chosen, then object to the process and run into court claiming that there was a lapse, and ask the court to choose a new arbitrator?
Well, my answer to you, Your Honor, is that in this case, there was a bona fide good faith reason why there was a dispute. And furthermore, the hotel immediately, before having a decision from this arbitrator.
I think you'll want to address the whole panel.
Okay, I'm sorry, I'm looking at.
The screen is not where Judge Rovner is.
Okay, sorry. So, in this case, there was a legitimate beef with the way the whole process took place, and I would submit that this court has instructed that when you have such a dispute over the selection of the arbitrator, then you immediately bring it to the attention of the court, which is what happened here. This wasn't a situation where the party waited until they got the adverse decision to do that. So I think that was addressed by the court in one of its decisions about how a party should do that, and that's the WellPoint Inc. versus John Hancock Life Insurance Company.
And can I confirm, are you appealing, we have two different judges here, are you appealing the original judge's ruling where the court granted the motion to compel arbitration?
Yes.
And addressed the selection? Are you appealing I think it was Judge Perry, the subsequent judge's decision where you essentially moved to reconsider, it seemed like?
Well, the first judge's decision could not be appealed. It was an interim decision. She stayed the case.
I understand you couldn't appeal it immediately. I'm just trying to confirm exactly what you're appealing today.
We're appealing both decisions. It was submitted to Judge Perry to reconsider. She just followed what the first judge did. And then we were also presented to her why the decision was against public policy and shouldn't have been confirmed.
How do you get around the arbitrator's factual findings about the knife incident here? We essentially don't touch factual findings of arbitrators. It's virtually impossible to do that. And it seems you'd have to prevail here on your public policy argument, we'd have to ignore those factual findings. You disagree with them, I understand that, but we'd have to ignore them. And how can we do that?
Well, in this case, Your Honor, which is very unique, in none of the cases that the union cited do we have a video footage of the entire incident showing what happened. And this court in the Pojecki case, which we cite in our reply brief, stated that, we're not going to ignore what the video shows. So in this instance, the court can see the video for itself. Secondly,
Mr. Keslowitz, are you really arguing that any time there's video that we can ignore the long-standing precedent about when courts can, can review arbitration awards and simply make our own factual determinations? I may think that the arbitrator was completely wrong in his decision in this matter. He obviously had no idea how a woman would feel if a man walked toward her with a knife drawn with that look on his face. But, no matter how what I think, the parties bargain to have your dispute settled by an arbitrator. And you can't come back out of that bargain and have it decided by the court. I'm sure you've taken a look at quality custom distribution. And it's a problem for you.
well, Your Honor, I would answer that by saying matters of public policy are for the court to decide. And when an arbitrator's findings may be contrary to that public policy, then it cannot be confirmed. In this case,
In what sense contrary to public policy?
reinstate.
If the hotel had decided to keep this man on the payroll, would that have violated Illinois law?
Well, it may have been contrary to the Illinois Workplace Safety Prevention Act, the Illinois Workplace Violence Prevention Act.
Simple question. If the hotel had decided not to fire this man, would that have violated Illinois law?
It's questionable, Your Honor, because the employee had a right under the Illinois the Workplace Prevention Act, to not have a
So the
person-
hotel could have been prosecuted and convicted of what?
not
concretely?
convicted, but could have been sued by the employee. Possibly.
Anyone can sue about anything, right? We could have been sued is no response. Do you have some Illinois case saying that in a circumstance, anything remotely like this, the hotel legally must fire the worker?
I cannot give you a case that says that, Your Honor. But then again,
I don't think there is one. And then you have the problem, which is that the arbitrator is effectively the party's delegated agent. Any decision the hotel can make, the arbitrator can make on its behalf. So if the hotel would not have been in violation of Illinois law, how was the arbitrator in violation of Illinois law?
well, the way the arbitrator is in violation of Illinois law is that he had to consider, as part of the public policy duty of the court, he had to consider the issue of reinstatement. Would the person's reinstatement have harmed the workforce, or possibly created a situation where there could be a future harm?
But that's where the factual findings come in. He
Well,
made specific factual findings, and not just based on the video, but based on the fact that the hotel knew this employee came and carried a knife. He'd been a good employee for 30 years, so the arbitrator made pretty detailed factual findings here that in order to go down the route you're proposing, we would have to question those or find that they're wrong.
I would say that he didn't make any findings about whether this person would be a safety risk to the workforce by being reinstated. And that's the problem. He didn't express contrition. He had done this before. whatever he had done with previous employers, you have to remember this employer came on the scene at the end of, in 2022. And there was nothing to indicate, nothing in his decision to indicate that he took into consideration what this meant, reinstatement meant for the workforce. And therefore, that's for this court. This court can look at that and say, you haven't done it, and we don't think there was anything in the record that satisfied that. There was one Illinois Supreme Court case that said the arbitrator has to address that. And if he doesn't, then you don't defer. Does the court have any questions with respect to the...
Let me rephrase my question.
Okay.
Suppose instead of taking out a knife, the employee had come up to the other worker and just frightened her, said things that frightened her. Would the hotel have been required to fire him? Legally required to fire him?
I can't answer your question unless I knew exactly what it is he said. If he said, I'm going to kill you, that would be one thing.
Suppose he comes up to her and says, I hate people who are, and then he names her ethnic group or her sex, makes a scowling face and walks away.
That may not have been a situation like this one.
I'm not asking whether it was a situation like this one. There is a public policy against insulting and frightening workers. There are all sorts of public policies. The situation I'm giving is one in which the frightened worker would have been entitled to collect damages for defamation, for the insult, for the fright. Does that require the employer to fire the other worker? It's not does it entitle, it's does it require as a matter of Illinois law?
I can't say whether it requires, but I can say this, that the policy here was a zero tolerance policy. The contract gave the right to the employer, the hotel, to determine the appropriate discipline because it was zero tolerance.
We're not asking about the hotel's policy. Your argument is one about the public policy of the state. And presumably you can find that by looking in state statutes or decisions of the state courts. So I'm asking, does the Illinois judiciary require an employer to fire the worker in the kind of circumstances I've outlined?
And as I said before, the statute doesn't directly say that.
Does some Illinois case say that?
I cannot point you to an Illinois case that says that. Well, and Your Honor, I don't mean to cut you off, but I'm running over my rebuttal time. Thank you.
Thank you, counsel. Mr. Kennedy.
Good morning, mate. Please the court. Pardon me. I'm Wesley Kennedy, representing Plaintiff Appellee Unite Here Local 1. Arbitration is a matter of contract. Under federal arbitration policy and under federal labor policy, parties enter into arbitration agreements and we enforce them. In this case, the parties had a contract to select the arbitrator by random drawing from a standing panel of arbitrators without any exception or any restriction on the same arbitrator getting 2 cases in a row. An arbitrator was selected. The employer didn't like that arbitrator in this case. The employer has said in the meeting, and it says in its brief, we would have accepted this random selection process if it excluded that arbitrator from the pool. So the real beef is not with the process, it's with the arbitrator who is part of the standing panel under the contract. The first question before on the first issue, the question before the court below was whether to exercise its authority under Section 5 of the Federal Arbitration Act to ditch that outcome and select another arbitrator. Well, the first clause of Section 5 is clear. If in the agreement provision be made for a method of naming or appointing an arbitrator, such method shall be followed. So the question before the district court was, had the arbitrator been selected by random drawing in accordance with the CBA? And the court properly said yes. The random number generator is random. It doesn't use seed numbers. It doesn't use algorithms. It is not subject to manipulation. The union didn't know how it worked internally anyway, so the union couldn't have manipulated it if it wanted to. And even the authorities cited by the defendant in its brief recognize the randomness of this process. In its brief, the employer says, well, this isn't a drawing under the contract. Well, that wasn't argued in the district court, so it's not properly before this court. At any rate, the use of the random number generator is a drawing. It's a drawing good enough for the Illinois Lottery to do its daily numbers drawings by random number generator. So what the company is essentially asserting is that they want the right to rewrite the panel of arbitrators in each particular case if it doesn't like a particular arbitrator. And the tell, again, is that their real objection is to the arbitrator, not to the process. So that really ends the conversation under the first question. There is no lapse under Section 5. It's contrary, asserting a lapse where the arbitrator has been selected in accordance with the contract would be contrary to the language of Section 5, the first clause. It would also be contrary to the rules of statutory construction. The employer asserts the right. The employer asserts the right in any case, for any reason, to say, I don't like this particular arbitrator selection. I refuse to participate in the process, and that creates a lapse requiring the court to intervene. That's an absurd result. You shouldn't read the statute that way. And it would also eviscerate the bedrock principle of labor arbitration policy, which is that arbitration is a matter of contract. The employer's interpretation of Section 5 would allow any employer any time to walk away from its contract on the arbitrator selection. The defendant has not cited any case in which a court appointed an arbitrator under Section 5, where the only objection was the employer didn't like the outcome of didn't like the arbitrator. Mr. Geslowitz referred to the Wellpoint case in his argument. The Wellpoint case, there was a process in which each party selects one arbitrator, and then there's a third arbitrator selected. In that case, one of the arbitrators quit. And instead of permitting the parties to appoint a new arbitrator, which is what the contract said, the arbitrators appointed their own third arbitrator. So that case does not apply. The employer asserts that there is a disagreement on the method by which the random the random process was carried out. It's mostly based on the pejorative name calling against the union. There's no indication that the union did anything but in good faith apply the random number generator in the same way that it applies it under multiple contracts, providing for the same language without any objection.
Is that a method that the union frequently uses?
The union has at least 8 agreements with hotels which provide for this same random drawing selection from a standing panel. In each of those cases, the union uses random.org in every case, and this is the first case in which any employer has any objection. Now, Mr. Geslowitz would tell you that the
Has
practice.
anybody analyzed these choices over time to see whether they're actually random?
I don't know the answer to that question, Your Honor.
Well, there's certainly no evidence in this record about
There's
that.
certainly no evidence in this record, and the declaration of the person who administers this process is that there are cases where the same arbitrator gets picked 2 times in a row, and I can tell you from experience under these contracts that that's true, and nobody has ever objected. And if they wanted to have a different process for selecting a party from a standing panel, the parties could bargain that. But they didn't in this case. So the employer's real argument about the strike, about the unfairness of the process, it relates to one reference to the word striking in one email. The contract doesn't say alternate strike. The contract says random drawing. They had the contract. That reference was in a different email chain. That in response to that email, the employer said, well, no, we want to have a grievance meeting, which the union did, and then afterwards there was a new course of communications which led to the selection of the arbitrator. And again, when they got to the meeting, the Zoom meeting to select the arbitrator, the employer representative said, if you'll take Peter Myers out of the pool, this is okay. So the real beef is with the selection of the particular arbitrator. So there's no basis for the court to find, there's no basis for the court to find that there was any basis for the court, through the district court, to get past the first sentence of Section 5, which is to enforce the contract. On the second issue, I can tell that I don't have to go through in too much detail the standards. The review of the arbitrator's award is subject to the very broad deference under federal arbitration policy, so long as the award draws its essence from the agreement, so long as the arbitrator is even arguably construing or applying the contract. The fact that then the arbitration award is valid, even if you disagree with it. The arbitrator has particular breadth of discretion in fashioning the remedy in a particular case. And most importantly for this case, as you've already anticipated, the court has no authority to review the factual findings of the arbitrator. Under the Misko and the Garvey cases, the court may not revisit the arbitrator's findings of fact. How an arbitrator chooses to weigh the evidence before him is not a matter for the courts to re-examine, even if improvident, even if silly. The silliness is the legal standard. Arbitrator Myers heard all the evidence, looked at the surveillance video, and made detailed findings of fact. The knife wasn't a switchblade. The grievant didn't brandish the knife. The grievant didn't intend to frighten the coworker. The grievant held the knife for a split second and then put it away immediately on request. The grievant didn't know that the knife might have been illegal, and in fact, he had carried it around in the workplace for years with the employer's knowledge. The police came, but the police took no action against the grievant. And the arbitrator found that the grievant...
No action? I thought they confiscated the knife.
Well, I think they took the knife.
Yes.
And there is a one-page report...
Seizing something is certainly action.
Okay. They did take the knife, but there were no charges. There was no report of some alleged violation of some municipal code provision. There's a report that says, yes, we came and we saw the grievant. That's in the record. And in any event, the arbitrator found that, among other things, that the employer had condoned this conduct for carrying the knife around for years. Those are all factual findings based on an examination of the evidence. They are unreviewable by this court. The court has to take them as it finds them, even if you disagree with them, even if you think they're silly. Now, Mr. Gestwitz said, well, this case is different because we have the surveillance video. Well, no, it's not different. The surveillance video is a piece of evidence, like everything else. The arbitrator looked at it. The arbitrator entertained arguments about it. The arbitrator made findings of fact about what's on the surveillance video. Those are factual findings that the court has no authority to review, even if you think he's wrong. But he's not wrong. Both parties have looked at this 20 seconds of the surveillance video. The arbitrator looked at the 27 seconds of the surveillance video. 2 district courts have looked at it, and nobody agrees with the employer's characterization of the video. So the arbitrator's factual findings, which really are the core of his award, have to be accepted. There's an assertion that, well, the arbitrator didn't consider the risks of reinstatement. That's really all wrapped up in the factual findings, that the arbitrator found the facts that he did, and on that basis, there was no reason to believe that, particularly if the grievant understood he wasn't supposed to bring the knife back, that there was no reason to believe that there would be any harm to the workforce if the grievant was reinstated. And the union represents the workforce.
We lost Judge Wolf.
Oh, dear.
Oh,
Yes.
You want to hold it?
Well, please see if you can find her again.
all right. I assume my time will be frozen at 4:14.
It's frozen.
Back to the issue of reinstatement, which I was discussing when we lost Judge Rovner. As I said, that's all wrapped up in the arbitrator's factual findings, and implicit in that is at least implicit in that is a consideration of the merits of reinstatement. And reinstatement is an issue that arises in every discharge arbitration where the union prevails. The question is, should reinstatement be the remedy if there's no discharge? And arbitrators consider and interpret and apply that standard every day on all kinds of issues. And the arbitrator's assessment of the remedy in this case is frankly right down the middle of the fairway in remedies. In discharge cases, reinstatement would make whole relief. In this case, the arbitrator found that some discipline was warranted, so he adjusted the make whole relief on that basis. That's a perfectly appropriate remedy. The award drew its essence from the agreement. The arbitrator interpreted and applied the just cause standard, which is written in the contract. That is the gold standard of standards in discharge arbitrations. It's in thousands and thousands of collective bargaining agreements, and arbitrators interpret and apply it every day. And you can see at page 52 of our brief, this court has affirmed numerous arbitration awards issued under the just cause standard. Mr. Gessowitz makes reference to a zero tolerance policy. Employers implement zero tolerance policy. The employer's unilateral policy isn't in the contract. What's in the contract is just cause, which is a different question and a broader question that the arbitrator interpreted and applied in accordance with his authority under the labor laws. So there's no basis within the standards of the contract to find that the award was in any way invalid as a matter of interpreting and applying the contract.
Now, counsel, an arbitrator cannot order a party to violate state or federal law.
Okay.
So the question is, does any Illinois law or decision prevent the hotel from employing this man following his use of the knife?
No, and to the contrary, as you know, as you obviously know, the public policy exception is even if a kind.
I'm not asking about the public policy exception at large.
Okay.
I'm asking a concrete question. It seemed to me that the lawyer for the hotel had not researched this question. He didn't know one way or the other when I asked him. Have you researched this question?
Yes, and it's in our brief. Mr. Gessowitz makes reference to the Illinois Workplace Violence Act, which is a statute. It is, and it does state Illinois policy. But Mr. Gessowitz can't find a case that finds that under the public policy exception, that statute overrides an arbitrator's award.
I'm not asking. Look, I want you to listen carefully to what I'm asking. I'm not asking about arbitrators. Forget about arbitrators. Would it violate Illinois law for the hotel to decide on its own to retain an employee under these circumstances?
No. We cite two cases in our brief which rejected the Illinois Workplace Violence Act as a basis for applying the public policy exception. The University of Chicago versus Teamsters Local 743 case, in which the arbitrator found as a fact that the employee had repeatedly made physical threats against their supervisor. Notwithstanding that factual finding, the arbitrator reinstated the employee. The employer asserted the public policy exception under the labor laws, and that was rejected by the district court. The second case is the Central Management Services versus ASME case, in which the employee used profanity, called the supervisor names, attacked the supervisor physically, causing physical injuries, and was criminally charged with battery. The arbitrator accepted all of those as facts, reinstated the employee.
Thank you, counsel. But I hope I was clear. I am not asking about arbitration cases. Thank you very much, counsel.
No, but the answer to your question is no. Thank you very much, Chairman.
Mr. Gessowitz, anything further?
Yes. I'd like to remind the court that if the arbitrator was not properly appointed here, then the whole issue about what the arbitrator did becomes moot. And there's one thing here that's in the record that really is a matter of no dispute, and that a bona fide deadlock had occurred. And there was a good reason why the employer did not accept this appointment. First, although the CBA calls for the selection of the arbitrator by random drawing, the parties never used that method. In this instance, the union's email agreeing or inviting Mr. Ward to a meeting to select the arbitrator said it would be by a striking process, i.e. alternate striking of names. Mr. Ward attested that he was okay with this because that would mean no thumb on the scale. In short, there was an agreement to use a striking mechanism.
But how can that trump the contract?
Because the parties can always choose another method of doing it. The fact that it says random drawing in the agreement doesn't change it. And furthermore, the hotel, in this instance...
Are you saying that one party can do this?
I'm
One
sorry?
party can just change it?
It wasn't one party. It was acknowledged that that's the way it was going to be done. That's what Mr. Ward felt was going to be happening. When he went to the Zoom call with the union representative, he was confronted. He was blindsided, as he termed, with what she described as a web-based number generator. He attested he knew nothing about that generator, how manipulable it was, or whether it was truly random because it was computerized. He did offer to compromise by letting her use the number generator if Peter Myers' name was left off. But that was because Myers had been unilaterally appointed to an arbitrator in a case that was then pending on subcontracting.
If you make the argument you're making now, before Myers was selected?
Before he was selected?
I mean, you're saying that the random number generator is not in fact random.
Well, that was how it was perceived by Mr. Ward when it took place.
Do you have any evidence to that effect?
Of what? That it's
That it's not in fact random?
Well, we cited in our brief that since it was a computerized system, computer methods by definition are not random, they're pseudo-random.
Well,
Do you have any evidence that it produces results that are not random?
Your Honor, I'm going to answer your question by saying that what matters is what happened here. He
All right.
did not know anything
I take it
about
the
it.
answer is no. Thank you, counsel.
Okay.
The case is taken under advisement. Our second case of the day is Janke against Girach. Ms. Volpe.
Good morning, Your Honors. May it please the Court. Ariel Volpe on behalf of Petitioner Terrence Janke. Mr. Janke is currently spending 30 years in prison in connection with an overdose death of a woman because his trial counsel failed to call a material exculpatory witness. The District Court never considered the merits of it because it found that Mr. Janke had procedurally defaulted. That was error. As Mr. Janke explained, the prison's miscalculation of his deadline prevented him from gaining access to the law library until the night his petition was due to the Wisconsin Supreme Court. That establishes cause. The state acknowledges that
I must say I don't understand that argument. I don't understand even that that argument was made in the district court. Your brief seems to confuse the amount of time available to all inmates with the extra time available to inmates with looming deadlines. But what I didn't see was an argument that the petitioner had tried to use the regularly available time and been unable to use it. Was such an argument made?
Well, Mr. Janke below said that that sometimes inmates have 40 minutes, sometimes they have none at all, and it's the prison policy to give inmates guaranteed access based on their deadline.
I understand about the guaranteed access bit, Was there an argument in the district court? For that matter, is there an argument here that this man attempted to use the regularly available time and was unable to do it?
I think it's implicit in what Mr. Yanke said before the district court that he obviously didn't have time to prepare his petition until he was guaranteed access.
He had quite a lot of time, quite a number of days. I could imagine saying, I went on Monday and they turned me away. I went on Tuesday, they turned me away. I went on Wednesday, they turned me away. And my time finally ran out. Was there anything like that in the district court? There certainly is not on appeal.
I think, so the district court didn't hold an evidentiary hearing on this?
I'm not asking whether the district court held a hearing. I'm asking whether he made that kind of contention in the district court.
I think it is implicit in what he told the district
In
court,
other
but he
words,
did
the
not
answer is
explicitly.
no. He did not.
He did not say that he attempted to use the library on this, and this day.
Everything seems to have been focused on this reserved time or guaranteed time rather than the regularly available time. But what reason do we have to think that the regularly available time was inadequate?
Well, because he wasn't able to prepare his petition. If he had access to the regularly available time, then
We don't even have an affidavit from him saying, I tried to use the regularly available time, but was turned away, or anything like that.
well, again, I think
That's a factual assertion that is very important, at least to me, and seems utterly missing. Now, I know it's too late for you on appeal to do what your client did not, but is there any facsimile of that in the district court?
Again, I think it's implicit in what Mr. Yanke said, and he was pro se before the district court, so this court can construe what he said liberally, and I think liberally construed, he did say, sometimes you only have 40 minutes, sometimes you have none at all. I think it's implicit that he didn't get that time, and so, as the state acknowledges, there are factual gaps in the record, and so the correct course of action would be to remand to the district court so that the district court can accept evidence about what exactly Mr. Yanke did and how he was prevented from accessing the law library before his petition was due.
And just to clarify, your argument is not that procedural default should be excused because the librarian allegedly gave him the wrong due date. Your argument is based on the lack of access to the law library because of that, correct?
Correct. It's the connection of the two.
And I think I'm sorry.
No, go ahead.
I think the challenge in the record is that below he argued that he didn't have access to the law library until April 12th, which was the day the application was due. But it's hard to, there isn't anything else leading up to that he didn't have access. What about the week before? Typically you see some type of an affidavit or something to raise that particular factual issue.
I understand, Your Honor, and again, Mr. Yanke was pro se below, so I think he did the best he could, and that's what why he said, sometimes you only get 40 minutes, sometimes you get none at all, and the way I think the fact that the prison has this policy in place that guarantees inmates access is an acknowledgement that they don't have adequate access leading up to that time. So that's why inmates have to give their decision. That's why the prison librarian calculates the deadline, and that's why you get 3 or 4 days of hours of blocks of time, because as we all know, it takes time to prepare a petition to vindicate your constitutional rights. So again, I think Mr. Yanke did the best he could, being pro se before the district court, and we think the proper course is to remand for the district court to address those evidentiary gaps. And a remand wouldn't be futile. Mr. Yanke did present a meritorious ineffective assistance of counsel claim. Mr. Yanke's trial counsel, Mayer, failed to call a material exculpatory witness that would have toppled the two pillars of the state's case. At trial, the state argued that Mr. Yanke provided the heroin.
I don't think there's any point in trying to get into the merits. The district court didn't reach them. If we agree with the procedural issue, we'll remand to the district court.
Okay, Your Honor. If the court has no further questions about the procedural count, I'll leave the rest of my time for rebuttal.
Mm-hmm.
Thank you.
Thank you, counsel. Mr. Kellis.
Good morning. May it please the court. John Kellis on behalf of the respondent. Without a sufficient evidentiary record to support his requests, Mr. Yankee is asking this court to effectively find cause and prejudice to excuse his procedural default, and then also declare his trial counsel ineffective based on unproven and untested allegations. And I'm asking this court to reject those requests and affirm the district court's order and judgment here. Holding, I guess, first and foremost, that the stated excuse for why Mr. Yankee had not filed his petition for review in the Wisconsin Supreme Court as a matter of law does not constitute cause. I mean, with his allegations below that a law librarian effectively misguided him about the date that it was due, and this, I guess, distinction between how much time is available and what the average, or I guess what the normal routine prisoner might have access to. At the end of the day, there wasn't really an allegation here that prevented him from actually getting his petition for review filed in time.
We are dealing with a pro se. And while it is true that the arguments in the district court were slightly different than they are here, he did argue below, as I see it, that the law library hours were restricted and that he was not guaranteed any access to the law library until the day his petition for review was due. Although it's true that he did not specifically mention the fact that he was not given library time until just before and after his filing deadline. Why isn't his argument close enough to the one he is making now to deem it not waived, particularly because we do review pro se filings generously, and we allow pro ses to refine their arguments on appeal when they were pro se?
Two things. I guess first and foremost, I acknowledge that yes, as a pro se party, this court has routinely liberally construed pleadings. District courts do as well, and I'm not trying to challenge that. I guess the issue that I see here is that this isn't a matter of saying, as the argument is in the appellate brief, that he effectively had no ability to do the research or work on this until the day it was due. That's not what the argument was made below. If that were the case, I suspect the district court very well may have had an evidentiary hearing to test some of those allegations. What the allegations really were below, though, is that we effectively have, maybe some reduced time in which an individual can have access to the law library, but there's not even any indication that was inadequate, that there weren't enough hours. And it was really focused more on this librarian giving the incorrect date and not the connection of, well, if the librarian gave me the wrong date, that then prevented me from getting access until the day it was due. And even that is not, there were no allegations made below either that this was a situation in which the first day that he was allowed, that he had preemptively, when he received the Court of Appeals decision, that he's taking the steps necessary to get access to the law library, that he's submitting that. The only thing that was submitted as far as the actual library documents had to do with the week of the petition being due. Nothing to indicate that he actually had made any request before that. Nothing to say that he had been prevented from doing anything before that. What we really have is, I guess, a belated assertion now that the prison did not allow him to have access to the library until the day of. But again, that's different than the allegation of, well, maybe we can only have an hour or two per day, some days not at all. there's a difference there. And I think that that's really the problem here, is that by not articulating what the I guess in his view, the true reason was for not getting his petition filed on time, we don't have a record to establish what actually happened. And I think that that's really the critical problem here, is that because of the pleading deficiencies here, not only do we not have a record for it, but even as illustrated by the district court's decision below, it wasn't even apparent to the judge that his argument, that Mr. Yankee's argument was that he didn't have access or enough access to the library in order to get his document prepared and filed. I will indicate, so based on the arguments that were made, I am asking this court to effectively declare that the excuse of a law librarian gave me inadequate, or I'm sorry, the law librarian gave me the incorrect due date, paired with, not the, I guess, the most time that someone may want, or not unfettered access to the law library, does not constitute cause in order to excuse a procedural default such as this. If the court is not inclined to go that route, and if it decides that either this argument that was made was sufficiently articulated from the the appellate brief, that was sufficiently articulated below such that the court wants to revisit or address this, I don't see any route that can be accomplished without a remand for an evidentiary hearing. As indicated, we have effectively Mr. Yankee's assertion about what access he had, what restrictions were placed on him, what the law librarian did, and that none of that has been tested, none of that's been definitively established at all. There's really no way for this court to decide based purely on that whether he actually established cause to overcome this procedural default.
Could we jump to the merits?
We could. I think that's, I guess, the other issue here is prejudice. Even if he establishes cause, that doesn't necessarily allow him to overcome. Even
though the district court didn't address the merits.
Correct. I mean, I think, I see where you're going. I think that if the court is confident still that there's a lack of prejudice from the record, I think it could go that route. But even that, I guess, is problematic in that if the court believes that it cannot decide the substantive ineffective assistance of counsel claim, which even that would be really difficult to do because, again, there's been no evidentiary hearing on that claim either, it would be difficult for this court to say that there's any real, that there was merit to that claim or that there was established prejudice that would go along with that cause and allow him to overcome.
Could the petitioner even get a hearing on that claim, though? Not a hearing about cause and timeliness, but a hearing on the ineffective assistance of counsel claim before the district court? Hasn't Shin foreclosed that?
I think given the lack of evidentiary record, I don't see how he would otherwise have any chance of prevailing on his claim short of that. We haven't had...
No, I think, counsel, this is a question about 2250E.
The court's factual foundation.
Correct.
For ruling that trial counsel's decision not to call the witness Anderson, for instance, was strategic. Did the state court, did the state court unreasonably apply Strickland by making this determination about the trial counsel strategy without having any testimony from the trial counsel? Yeah, sure, it's true. He had secondhand, that appellate counsel had been in touch with trial counsel, but maybe some of that's just hearsay. I don't know what it could be.
No, I understand, and I think this might get into a distinction, and it's not really, I guess, addressed in our brief so much as this distinction between an argument based on Strickland and whether this was with contrary to or unreasonable application of Strickland, as opposed to potentially like an Anders claim to suggest that the court didn't conduct the proper inquiries or go through the right steps in order to determine that there was no arguable merit. But that's not the claim that was raised in the district court or before this court. We have this standalone claim of Strickland, and based on the record that's before the court and the representations made by appointed appellate counsel, I don't think that was an unreasonable application. I mean, we have, Strickland obviously is very deferential to counsel's decisions. We have these representations that this particular witness, Anderson, had a whole slew of issues regarding his testimony and his multiple changing stories and the issues with the credibility and how that could have impacted the trial, I guess, against the defense. So with that, given the information that was presented to the court at the time, I don't believe is an unreasonable application. The court acknowledged the standard that it was to apply, I believe recognized Strickland here, and it's not, even if this court were to believe that maybe it would have decided differently on this exact same Strickland claim, that doesn't mean that it's unreasonable. Fair-minded jurists could look at this record before the court and decide that it was a reasonable decision not to call Anderson to testify. So because of that, I guess it's kind of twofold here. We have the lack of cause because Mr. Yankee either failed to preserve his arguments for why this court would entertain these arguments, but also the lack of prejudice in that ultimately his claim is a losing one on ineffective assistance of counsel. The circuit or the Court of Appeals was correct here to conclude that it saw no merit to that, and because of that, I think even if the court were to go that far to conclude that an evidentiary hearing might be warranted to the established cause, that even so, maybe that's all for nothing.
You might want to come back to the question whether 2254E permits an evidentiary hearing.
I believe, and I'm sorry, Your Honor.
So I'll give you a little bit more on that. The Supreme Court in Shin said that a federal habeas court cannot conduct an evidentiary hearing in a Strickland claim unless you meet the requirements of 2254E, which would require that the new claim rest on a rule of constitutional law or you're presenting facts that couldn't have been presented below.
I guess I don't know. I mean, granted, to some degree, Mr. Yankee had the opportunity to present information to the Court of Appeals when the no merit report was filed. So I guess it's not as though he didn't have the opportunity to present something. I'm not positive, unfortunately. I guess in the end, though, I don't know if the court, or I should say, the court really doesn't need to get there, just because the lack of established cause here at most would warrant an evidentiary hearing to address that. But for the reasons that we've stated here, I'm asking that the court even reject that request, given the fact that that's not what Mr. Yankee argued below. And he's effectively, it's not so much a nuanced, or I guess an evolving argument. I mean, this is a different argument than what he made below. So with that, I am asking that the court affirm the district court's decision to dismiss Mr. Yankee's petition, and that's all I have. Thank you, Your Honor.
Mm-hmm. Thank you, Mr. Kellis. Anything further, Ms. Volpe?
I just want to make 2 quick points. One, with respect to this forfeiture argument, Mr. Yankee did, I think, present the ingredients. This court, reading what happened below, recognized that there might be an event external and granted a certificate of appealability and appointed counsel to argue this on appeal. And so that's what we've done. I think those, again, the ingredients were there. We just repackaged them and made it crisper. Two, with respect to your Honor's question about Shin and whether the court can hold an evidentiary hearing, we respectfully request that this court order supplemental briefing, very short, just to address that question. Thank you.
Ms. Volpe, for your willingness and that of your law firm to accept the appointment in this case, and your assistance to the court as well as your client. This case is taken under advisement, and the court will take a brief recess. Ready for argument now in the case of Radant against Douglas County. Mr. Korb.
Thank you, Your Honors, and may it please the court, I'm an attorney for the petitioner Christopher Radant. Mr. Radant is the alleged victim of excessive force, where the allegation is that he was thrown into a concrete bunk head first, and that the allegation is that he suffered traumatic brain injury, a labral tear that required surgery in his shoulder. He had, just 2 weeks before this, had a surgery on his wrists. That surgery had to be redone, and he also suffered PTSD. The case was dismissed, at least part of the case was dismissed at summary judgment by the district court. The issue was for the district court was that there was a video that captured some of the events of the evening when Mr. Radant was arrested, and that was the grounds for summary judgment for most of the case.
Mr. Korb,
Yes.
For the purposes of qualified immunity, which specific acts by the officers would you say were so far outside of the range of acceptable use of force that the officers would have had reason to know that their actions were illegal?
Well, Your Honor, I think it goes to the totality of the circumstances. When the Graham versus Connor, the really seminal case and excessive force cases that we all know, this is, there are many factors here that are at play. One of the issues here is the actual underlying offense that Mr. Radant was alleged to have committed. He was driving a vehicle in violation of a probation. This was a non-violent offense. He was handcuffed at the time behind his back. He was not a flight risk. He had been taken through a locked doors into the booking area. In the booking area of the jail, there was an officer. There were two, not only the arresting officer, but there were also 2 other the jail deputies there. This was a very secure facility. He had to go through a locked sally port to even get into the booking area, and then he was taken from a booking area, through it down the hall into a receiving cell. So there are the very secure facility, and that's one of the issues is, not only how many officers were involved. There were 5 officers that were involved in this case. So
Which specific acts by the officers are you know, if you
Yes.
could
So
help me.
Yes, so there are a couple, and this is where there are actually 2 videos in this case. One video is in the booking area that I mentioned, and there's another video in the receiving cell. The booking area video actually has a better quality, has audio. The video in the receiving area has no audio, it's very grainy. But in the booking area, the alleged act is that basically Mr. Radant, after having asked numerous times that his handcuffs be basically released or loosened, he was taken by the hands and forcibly taken by his arms. He was refused. The officers refused every request to remove or loosen the handcuffs.
But that claim went to trial.
That was part of it, but that actual allegation continued into the receiving cell. He still had the handcuffs on when he was taken down the hallway, and even the receiving cell as well. So I think it was error for the court to try and differentiate. The district court basically created 3 discrete steps or stages in the case as far as the force that was used. One in the booking area, one in the hallway, and one in the receiving cell. But to get back to the totality of the circumstances in this case, one thing that's very, very relevant in this case is that in the booking area, in the audio from that video, you can hear one of the officers actually tell Mr. Radant, you better stop or you're going to go on the floor. You're not going to go down gently either. That statement to me is an intent. It shows intent on the part of the officer, because moments later, Mr. Radant was then taken into the receiving cell and thrown into a concrete bunk. The allegation is that one of the officers, not only did they take up one of his legs at the time, there's a mattress that had been a slippery mattress that was on the concrete bunk. Our allegation is that that mattress was thrown off just before Mr. Radant was then thrown into this concrete bunk. So, yes, the allegation of the handcuffs was in the booking area, what the court allowed to go through as far as to trial in the booking area, but the far more egregious and more violent actions of the officers was in the receiving cell, and that was excluded. And this goes again to the totality of the circumstances. Even the injuries are part of the element of what proves an excessive force case. You know, how seriously someone is injured. The judge granted motions in limine that basically kept out every doctor I called. We'd already done the trial depositions of 3 doctors and a vocational expert that relied on those doctors' opinions. The judge kept excluded it all. And
If we affirm the court on the exclusion of the experts, can you prove causation?
If the case is allowed to proceed as far as the receiving cell, and then yes, I think we
How
can.
would you prove causation? Are there other experts?
Meaning causation that if you
That the
exclude
officer's actions caused the injury.
Okay.
So assume you're right on the excessive force, just for purposes of this question. But you're wrong on all of the expert issues. If we were to affirm the district court on those expert decisions, can your claim about the receiving cell go forward? Or can you not prove causation?
Well, we wouldn't be able to prove the causation as far as the medical treatment, but I think Mr. Redan would be able to testify regarding his injuries.
He could certainly testify about his injuries, but how would you prove that these officers caused those injuries if you don't have those experts? I don't know if you have other experts.
Well, that's why the doctor's opinions were critical. I do think you do need to have a doctor testify as to the causation of the injuries caused by what happened. And the exclusion of those doctors was in part, large part, because...
It seems to me if you lose on the doctors, that you lose the case because you couldn't prevail on causation as to the excessive force.
Well, I think you can always seek nominal damages even if there is no medical treatment.
But causation is an element of the claim.
So I think that the jury could find that, based on Mr. Redan's testimony, that yes, that he was injured. In fact, the judge did allow Mr. Redan to testify regarding
Again,
his
it's
injuries.
not injury, it's causation.
Yeah, but as far as the causation of the injuries, yes, I think Mr. Redan's testimony can lay the foundation for
And
the causation of
Brad's
injuries.
experts and his proposed trial exhibits were only relevant to the issue of damages for the claims against Libby and Larson, right? And those went to trial.
Well,
I guess the experts were expected to testify about injuries that he supposedly obtained when they failed to loosen his handcuffs in the booking area and allegedly twisted his shoulder while frisking him in that area. But the jury concluded these things didn't happen. So any damages would become irrelevant. And you didn't challenge the jury's verdict in the appeal. So I'm wondering,
So we're talking about two different things. The as far
Right,
as what the jury, the motion for summary judgment that basically took out all the allegations as far as what could be proven as far as what happened in the receiving cell, which again were the more significant problem that we had in the case. The more significant allegations arose from that. That was excluded, and then a month or so later, then the motions to eliminate were granted. And we can't have a fair trial in the case without having the doctor's opinions actually go to the injuries, which again are one of the factors that go into play where a judge or jury makes a decision about whether excessive force occurred. The severity of the injuries are an element here. And in fact, defense counsel in closing argument made one of their biggest arguments was they pounded on the fact that there was no medical testimony. There were no medical records showing any kind of injury. So how could there have been excessive force? By excluding that based on, and I want to remind the court of the reasons why that the motions limited were granted. They were granted because this report felt that the video showed that there couldn't, that what happened in the receiving cell was inadmissible. And when that was inadmissible, then Watkins was not allowed, Dr. Watkins in particular, was not allowed to testify because the receiving cell had been removed by the summary judgment order. Dr. Hoxie, he said he couldn't, the allegation was he couldn't determine the exact cause of a neuroma, and therefore the judge excluded all of his testimony, felt it was not an expert opinion. The district court felt that even though the doctors all gave opinions to a reasonable degree of medical probability and based their opinions on the self-reported history of the patient, that was inadequate. And that was not the proper standard.
The district court found you hadn't disclosed them. The district court found that these doctors were more than treating physicians, that they were actually giving opinions about causation, and you had failed to disclose them as experts.
That actually was not part of the judge's decision. If you read the decision, it was not based on a Rule 26 violation. It was based on, again, for Watkins, that there was not allowed to testify because the receiving cell had been removed by the summary judgment order. Hoxie because they couldn't determine the exact cause of the neuroma, even though Dr. Hoxie testified to a reasonable degree of medical probability, the gold standard by which all doctors, all physicians testify in any case regarding injury. And the case law is that you can have a condition, maybe have many causes. We only have to prove that the incident was a cause by a reasonable degree of medical probability, which we did, but the judge excluded the testimony because the judge felt there needs to be, that it has to be the sole cause. And it was inappropriate grounds to exclude all the doctor's testimony. There was also a physician, Barney, who the judge found.
The judge also found that Watkins was not properly disclosed as a retained expert, and he was giving expert opinions, even though he was the treating physician.
Okay. Well, and as we cited in our brief, treating physicians are not expected to have the same kind of level of working with the plaintiff's counsel, and no, we didn't have. They're not required to have every opinion in their 26A disclosure.
Treating physicians, if they give a causation opinion that was outside the course of their treatment, they become an expert, and you have to disclose it. The law is crystal clear on that, and the court found you hadn't disclosed him as a retained expert, even though he was giving this retained expert opinion.
Well, we did provide a report, and it is within also the grounds of the court to be able to hear the treating physicians are given more laxity as far as their compliance with.
Not when it comes to causation opinions that were not part of their treatment. They're still required to comply with the rules on disclosure.
Well, again, we believe that this even Schuyler was excluded, and again, these physicians not being allowed to testify really affected the liability, not just the damages aspect of the case. And part of the judge's rulings in excluding them was because he felt that they did deal just with damages and didn't have any bearing on liability when in fact they didn't. So that is another grounds for why there should be a reversal in the case. I also wanted to mention there's
Are you appealing the judge's ruling as to Officer Libby regarding the mattress incident? Because your brief really focuses on Larson, and Libby was not in the room. So it was unclear to me if you were appealing the decision as to Libby for the mattress incident in the cell.
So we're not contending Libby had anything to do with the mattress incident.
Okay.
She wasn't even in the receiving cell when it happened.
You generally say you're appealing it, but then your arguments are all about Larson. So you are not appealing the decision as to Libby regarding the mattress incident. Is that correct?
Regarding the mattress, correct. She was not involved in it at all. But we are asking for a new trial in regards to the entire case because these issues that happened in the booking area, again, under the totality of the circumstances, they really affect what happened in the receiving area and vice versa. And so excluding half of what happened, or maybe more than half what happened, really affected even the liability determination as far as what happened in the booking area. So yes, we do believe that the Court of Appeals can fashion a remedy here, and I think the only proper remedy in the case is to have a new trial. And this is, again, the video, coming back to the video, the Ferguson case, as I indicated, that's the main case that we're citing. In that case, we think that's the most appropriate case to follow. There was an Officer McDonough. He struggled to handcuff Ferguson, who was moving, but in that video it was hard to tell.
Thank you, counsel.
Thank you.
Ms. Mills.
Good morning, Your Honors. May it please the court, I am representing the Douglas County appellees. I believe the plaintiff's case in this instance has two major flaws, and the first is that the way that it was pled and proceeded on was very amorphous and mixed together, and I see it even in the way that counsel has been focusing on the totality of the circumstances. I think that the district court did a good job in trying to clarify and untangle that by categorizing this incident into three separate sort of mini incidents so that the district court could get a better handle on what it needed to decide, especially because there were different people involved in each of these incidents. So in the booking area, we really just have a claim against two people, Larson and Libby. It was for failing to remove handcuffs and then failing to loosen them. The court did decide on summary judgment that the failure to remove them was not unreasonable. It did decide that there was potentially a question for a jury of whether failing to loosen them was unreasonable because Mr. Redant was complaining about an infection on his wrist. That went to a jury and they determined there was no liability. The court then looked at, it was actually about 10 seconds if you watch the video. There isn't video in the hallway, but you can kind of watch the timestamps. It's about 10 seconds between when Mr. Redant was taken from the booking area to the receiving cell. That involved additional officers.
May I stop you here, because this is something I've been wondering about. How long is the hallway between the booking room and the receiving cell? I mean, we can see in the video the beginnings of the officer starting to take Radin down the hall. And we can see the end when he is thrust into the cell. But is there anything in the record about how long he is in that hallway? What may have happened while the officers were leading him down the hall?
So there is some detail in the record. There's nothing in the record that gives you any specific distance. So I can't say in feet or yards, but the timestamps on the video, which are on the same clock, if you will, it's about a 10-second walk. And so the other thing that we do know is that the officers were behind him. They did not lead him. They had, I believe one had a hand on one arm, one had a hand on another shoulder. And so they were behind him, walked behind him to the receiving cell, and that took just under 10 seconds. And so because that mini incident, I'll call it, involved additional officers, I think that Judge Peterson correctly decided that that would be looked at as sort of a separate use of force, particularly because Mr. Redant had at least originally argued that the officers, quote unquote, dragged him by his handcuffs down that hallway. Unfortunately, there is not video of that hallway, but you can see as he begins to be escorted down that hallway, he is not being dragged. The officers remain behind him, and then you can see on the video when he arrives at the receiving cell, the officers are still behind him. Then I'm sorry.
I'm sorry. No, you finish, please.
I was just going to say when he gets to the receiving cell, then that makeup of individuals who are interacting with him and using potential force changes again because Officer Libby joins them, but she's not involved. Only certain officers go into the cell, and then there's the allegations about lifting the leg to decentralize him, which ultimately he lands on the concrete bunk, but the mattress has slipped and he hits his head.
Can I ask you this, please? Why did they need to subdue him at all? Couldn't they have simply put him in a cell to cool off and sober up for a while?
The issue here was that they were unable to complete their pat search of Mr. Redant. And so there was testimony at trial. Unfortunately, it's not in the appellate record, but the officers said that it is very common that, and I think most people who have handled excessive force and civil rights cases in the correctional setting are probably aware that even if an arrestee is searched by an officer on site, that search does not necessarily get to the nooks and crannies that jailers have to get to when they are searching somebody. They need to search for contraband, they need to search for weapons, just like the arresting officer. And so what they were doing was taking him to the receiving cell so that they could complete that pat search, then remove the handcuffs and let him cool off, cool down. And of course, they had an obligation not just to protect him from fleeing. I know counsel said that he was no longer a flight risk, which is in all respects a reasonable conclusion because he's in a locked facility, but he could still pose a risk to himself or to officers because they had not been able to complete that pat search of him. They had, I believe, gotten through to his jacket, but there had not been any check of taking his shoes off, checking between the toes, no strip search, anything like that. They had not been able to complete that because of his resistance in the booking area. So I think that Judge Peterson and the district court did a great job of kind of compartmentalizing those so that the proper analysis could be applied to each use of force and each person using force to determine what actions was each individual taking, and did those actions fall outside of the range of acceptable conduct as established by our case law. There's no way that that proper determination could be made if we simply look at the event as if it's an incident from the minute that Mr. Redan stepped foot in the jail to the minute he hit his head on the mattress, particularly because one officer cannot be held responsible or liable for the actions of another. And so that type of, although it might seem sort of exacting, that type of very particular analysis is what is necessary to determine whether there was a constitutional violation.
Did he hit his head on the mattress or on the concrete floor?
It's my understanding that he hit his head on the on the concrete bunk.
Okay.
So as they were trying to bring him down, the mattress slipped. The allegation was that one of the officers purposely moved it out of the way, but in fact, it goes to one of the factors of excessive force that they did make the effort to temper any consequences of their force by putting the mattress down onto that concrete bunk to try to avoid injury to begin with. In the scuffle, the mattress slipped. There is no evidence that any officer purposely put their foot on that mattress and pulled it out of the way somehow. But he did hit his head.
The video's a little hard to tell on that because everything is happening so quickly. And Officer Larson walks in or moves forward and then the mattress slips.
Yes, so there is certainly arguments from the plaintiff appellant that the video in this case does not meet the standard that would be required to eviscerate any factual dispute. And so that we would say that while the video is not perfect, and of course I always wish that jails had HD cameras and perfect crystal clear pictures, we also had the testimony through declarations of all of the involved officers to sort of buttress that. And so to explain step by step what they were doing in relation to Mr. Redant, in relation to the mattress, and in relation to each other. And they all explained that the mattress, I believe one of Mr. Redant's feet was on it and that kind of motion slipped out. Now ultimately, even if the court were to assume that Officer Larson had his foot on the mattress and it accidentally slipped out, that still would not get to the level of a constitutional violation anyway, because it would simply be the unattended and accidental effect of an otherwise reasonable use of force. But it was unfortunately the situation that the mattress did slip just enough that when he did come down, his head hit the concrete and he got a cut on his head.
What about his own testimony that the officer intentionally pulled out the mattress?
So the district court did look at that and confirmed that he had no foundational knowledge to be able to make that statement. That Mr. Redant's declaration testimony was the only support for that. Mr. Redant stated in his deposition that he could not see what the officers were doing. He was not positioned in a way that would allow him to see that. And the court recognized that there was simply no way for Mr. Redant to then say in a declaration after the fact that it was a purposeful motion of somebody's leg who he could not see and had no basis to make that statement. And so ultimately, Mr. Redant's claims about who moved the mattress, their purpose in moving the mattress. It was all completely speculative, and there was no admissible evidence in the record that would allow that conclusion to be reached.
And of course, he was not following the orders to get on his knees.
That's correct.
Nor does he dispute that that.
That's correct. There is no audio, unfortunately, of the incident in the receiving cell, but it is clear from his body language that he appears to be resisting. I know that the argument had been made by the appellant that, well, he was just making motions or he was uncomfortable, something to that effect. Ultimately, though, the Fourth Amendment requires us to look at what a reasonable officer in the position of these individuals would have believed this individual to be doing. Based on the audio and video that we have of Mr. Adant in the booking cell, the booking area, I think it's pretty clear that they were reasonable in believing that he was resisting. Whether he was or wasn't, him locking his legs, pushing back against them, swearing at them, yelling, telling them they should go get help, all of that supports the conclusion that this individual, who has not cooperated with him for the first 10 minutes of their encounter, his physical actions in the doorway of the receiving cell and then moving towards that concrete bunk, it would be reasonable for any officer in that position to believe he is resisting, and some level of physical force needs to be used to get him onto the mattress, onto his stomach, where we can safely remove those handcuffs and complete the pat search of him.
Ms. Mills, you've relied on the Fourth Amendment here, and I know the court below did. Should the 14th Amendment apply here in light of Kingsley? Mr. Redant was a pretrial detainee who had not had his probable cause hearing yet, and we have maybe a little bit of conflicting case law on whether the Fourth or the 14th Amendment applies. In Kingsley, in a pretrial setting, the court said the 14th Amendment applies. The person at issue there had not had a probable cause hearing yet. It had started, but it hadn't completed. So I don't know that it ultimately matters on what the test is, but should it be the 14th or the 4th?
I agree that in this case, ultimately, it doesn't really make a difference one way or the other. I think in this case, because he had not had a probable cause hearing, he was actually not even completely booked into the facility. I think it was reasonable that the court decided, especially knowing that there wasn't going to be ultimately a difference in the standard as it applied, that the Fourth Amendment he could be considered an arrestee. There were also some arguments as to whether he was actually fully in the custody of Douglas County Jail at the time that this happened, because the arresting officer was still there. Had the jail actually taken custody of him? Ultimately, though, I think all of those are really interesting questions, but I think that in this case, the Fourth Amendment would be an appropriate one to apply given the facts, and it was somewhat of a unique circumstance. And then I did just want to touch on the issue of experts. These experts were all essentially asked the same question of, did the incident, quote unquote, the incident of October 10th, 2019 cause Mr. Redant's injuries? And I think that is where a lot of this ambiguity and vagueness comes back in as applied to the evidence of expert causation in this case. These experts responded in letters, and although they were treating physicians, they did respond and state, yes, I believe that the incident of October 10th, 2019 caused these injuries. But of course, as I said earlier, this wasn't one identifiable act or action of one or two individuals. This was 20 minutes involving multiple different people and multiple different allegations of physical action that were allegedly excessive. And so in a situation like this, when you have an expert who simply says, well, yes, my treatment of this individual was related to injuries caused by that incident, it is simply, it lacks the requisite foundational basis to connect any individual's conduct to the alleged injury. As the gatekeeper, the district court cannot simply say, well, this could potentially be relevant, or I'm not sure. the district court did exactly what it needed to do. It looked at the reliability and the foundation of those opinions first, determined that they were not reliable and excluded them. Also for the reasons discussed earlier with the failure to disclose them as experts rather than, well, as retained experts as opposed to treating experts. But in this case, that sort of ambiguity and bleeding from one thing to another, grouping everything together, truly meant that these experts would not have been able to offer anything relevant, probative, or helpful to the jury. I thank you.
Thank you, counsel. The case is taken under advisement. We'll hear argument now in Amtax Holdings against Full Circle Village Brook. Mr. Pettit.
Good morning, Your Honors. Eric Pettit for the appellants. May it please the court. This appeal involves a de novo review of a pure and narrow issue of contract interpretation. And so I hope to devote my limited time to addressing the relevant contract terms while pointing out along the way how they differ from corresponding terms in the various cases on which Full Circle relies, and how Full Circle's position cannot be reconciled with the language applicable here. The question presented is how to calculate Full Circle's option price under Section 7.4J of the Limited Partnership Agreement, or LPA. So it makes sense to start there. Significantly, 7.4J does not say that the option price is equal to the amount my clients would receive if proceeds from a sale of the property were distributed in accordance with Section 6.2. And so right off the bat, this LPA is materially different from the agreements
at issue. If you could use real words, we would appreciate it. You might have a private supply of initialisms, but we don't.
I apologize, Your Honor. The LPA is materially different.
If you could use real words, we would appreciate it. LPA is not a real word. It's a private initialism.
I understand and I apologize, Your Honor. The partnership agreement is materially different from the agreements at issue in 3 of the cases cited by Full Circle, specifically the Berkshire and Waterford cases in Florida and the Urban 8 Fox Lake case here in Illinois, since each of those agreements identified the specific distribution provision that applied to the option price calculation. Instead, Section 7.4J says that the option price is equal to the amount my clients would receive if the property were sold and the proceeds from such sale were applied in accordance with the agreement. Thus, we need to look beyond 7.4J to determine how proceeds from a sale of the property would be applied under the partnership agreement. Full Circle claims that we need to look no further than Section 6.2b. 6.2b, however, specifically states that it is subject to the provisions of Section 6.3 below. So we cannot simply stop there, but instead need to figure out how and or when 6.2b is subject to 6.3. Section 6.3b says that any capital proceeds from a terminating capital transaction remaining after payment of the partnership's debts shall be distributed to those partners with positive capital accounts in proportion to their capital account balances. Thus, unlike the corresponding provisions in cases on which Full Circle relies, including the landing case.
What happens if some partners have positive capital accounts and some don't? Would then only the ones with positive capital accounts receive any distribution?
Those distributions would be made to the partners with positive capital accounts up until the point that those capital accounts are fully paid, and then the remainder of any remaining proceeds would be distributed under Section 6.2b.
You know, that doesn't really answer the question either. Let me ask, here, the way I read the 6.3b language about positive capital accounts is that it's describing how proceeds are divided if there is a financial event whose purpose is the dissolution of the partnership. In such an event, any limited partners who have a positive account balance will receive proceeds in proportion to their positive account balance. And any partners with negative account balances will not receive any proceeds. I cannot, and I have really tried, I do not understand why you think the language about positive capital accounts shunts this transaction to 6.3b rather than 6.2b.
I think the answer to that, Your Honor, comes from the definition of terminating capital transaction. And that term is defined in the partnership agreement to mean a capital transaction that's either involving or resulting in the termination and winding up of the business of the partnership. So while a sale of the property in the regular course may not involve the termination and winding up of the partnership's business, it's indisputable that any sale of the property, regardless of the circumstances, will result in the termination and winding up. And the reason why we know this is because Section 2.5a of the partnership agreement says that the partnership shall be dissolved upon the sale or other disposition of all or substantially all the assets of the partnership. And it's undisputed that the property constitutes substantially all the partnership's assets. And that was expressly recognized by the Massachusetts Supreme Judicial Court in the TDC case. They addressed language that was identical to Section 2.5a and rejected the argument that the sale of the property and the dissolution of the partnership are sufficiently distinct events to break the chain of causation between the sale and the resulting liquidation. The court there concluded that the dissolution is mandatory and subject to no condition other than the sale. And similarly here, because there is no circumstance in which a sale of the property would not result in the termination and winding up of the partnership, every sale of the property is a terminating capital transaction, as that term is defined in the partnership agreement, and thus is subject to Section 6.3b, where, as here, the limited partners have positive capital accounts. And the final provision of, I'm sorry.
If we read the contract the way you request, seems to me that Section 6.2b has virtually no role, because all sales would end the partnership. So what would the role of 6.2b be?
So the role of 6.2b would be in two circumstances. First of all, 6.2b involves any type of capital transaction. And so if there's a refinancing, if there were a sale of, for example, the parking lot that the partnership owned, some sale that didn't involve a complete sale of the entire property, that would fall under Section 6.2b. And then the other thing is that, and this brings me to Section 6.3c. Section 6.3c says that the parties intend that as a result of the application of the allocation and distribution provisions contained in Article 6, any capital proceeds from a terminating capital transaction will be distributed in the same manner as capital proceeds are distributed under 6.2b. And so 6.3c kind of ties together 6.3 and 6.2b. And what it means is that as the partnership's tax matters partner, Full Circle was supposed to have allocated sufficient losses to my clients over the life of the partnership such that their capital account balance was either reduced to zero or equaled the 90-10 ratio in 6.2b. But because they failed to do so, my clients were denied taxable losses that were one of the key benefits they bargained for under the LPA, and instead were left with a large positive capital account. Full Circle never made any attempt to fix this because that would require Full Circle to pay taxes on gain it was allocated in order to right-size the capital account ratio and bring it into accordance with 6.2b. Thus, by seeking to benefit from the application of 6.2b without complying with the allocation requirements of 6.3c, Full Circle is seeking to have its cake and eat it too. In conclusion, our interpretation regarding the calculation of the option price brings all the provisions of the LPA into harmony without adding any language rendering any terms superfluous or meaningless. By contrast, Full Circle's interpretation relies on distinctions between sale proceeds and liquidation proceeds and between regular sales and bankruptcy sales that are absent from the LPA and would allow Full Circle to receive a windfall based on its failure to comply with 6.3C. And with that, Your Honors, I'd like to reserve the remainder of my time for rebuttal.
Certainly, counsel. Mr.
Thank you.
Davenport.
Thank you, Your Honors. Pleasure to be here. May it please the court. I represent the appellee. Initially, to kind of highlight the last point that counsel made, there was no claim below that my clients failed to allocate losses in violation of the partnership agreement, and that thereby caused this positive capital account to exist. The positive capital account exists by operation of accounting principles and the allocation of tax credits, the housing credits that go into the limited partner. Those benefits do not reduce the capital contributions. So the capital account starts at a number. Housing credits are allocated on an annual basis to the limited partner, but it doesn't reduce their capital account. What reduces the capital account is the allocation of losses. And there are only so many losses that can be allocated, and they got 99.99% of those. So the suggestion that we're going to have a windfall because we failed to allocate losses is just incorrect at best. Now, relative to the application of 6.3 versus 6.2b, it is also incorrect to suggest that when we were at the district court, all we said was, hey, look at 6.2b. We didn't say that then. We're not saying that now. We invite a wholesome review of the entire contract, section 2.5, section 6.2b, section 6.3, and section 7.4J. The district court recognized below that those were the 4 applicable provisions in the partnership agreement to answer the question of what this option price should be. We invited the district court to do that, and it did so. So when you do that, you're able to harmonize the contract and the various provisions within it that relate to how do you determine this option price. Section 7.4J clearly says we need to look at the fair market value of the property, what would happen if it sold, and what would the limited partners receive under this agreement from a sale. So you look at the other provisions in the partnership agreement to determine that. Section 2.5 makes it abundantly clear that there's a distinction between a sale and a liquidation. You then look at those provisions. What are the provisions that govern a sale? 6.2b, and it results in a 90-10 distribution of residual proceeds in favor of the general partner. It doesn't produce a windfall for the general partner. It thus finally, after 15 years of compliance and operation and doing everything that they were supposed to do as the general partner, they receive the economic benefit that they bargained for when they chose to participate in this program and invited the former original parties behind the limited partner into the partnership in exchange partly for this important option. And it allows the equity to remain with the property and be redeployed back into the community to do other things. That's the business deal. That's what's reflected plainly and unambiguously in this partnership agreement. And that's what this now limited partner wants to plainly disrupt to create a windfall for themselves because they want this positive capital account.
What about their argument about Article 1 and the definition of terminating capital transaction, making 6.3b kick in?
It doesn't make it kick in. A capital...
Because of the resulting in language.
Sure. I would respectfully submit it doesn't mean that it kicks in. I cannot dispute that the definition of terminating capital transaction has the definition to include a sale. But I would respectfully submit you have to look at 6.3 in the context of the agreement because the first thing we know from 6.3a is upon liquidation and dissolution of the partnership. Okay, so we're in 6.3 if we're in liquidation and dissolution. So the first thing you do is satisfy Section A. Then, because we're in liquidation and dissolution, if there are capital proceeds from a terminating capital transaction, then that's when that would apply. We're not there. We are under 6.2 because we're talking about a hypothetical sale of the property. So unless we are in liquidation or dissolution, the fact that the terminating capital transaction includes the definition that it does doesn't mean that we do it, right? We are looking at 7.4J and trying to determine from a hypothetical sale of the property, what would they receive? And 6.2 couldn't be more clear about that because you have the context of the definition, of the heading. We're not arguing that the heading changes or alters the interpretation of the agreement, but it provides very clear context for what the parties intended here. 6.2b, application and distributions prior to dissolution. So we have very clear separate provisions in the partnership agreement, and we have a very clear sequencing of events, whereby under 6.2a, if we have cash flow to distribute on an annual basis, we will do that. That is occurring prior to dissolution. Under section 6.2b, distributions of proceeds from a sale or refinancing. So if there is a capital event like a sale that occurs prior to dissolution, which we are talking about here as the hypothetical sale for the proxy for the option price, we utilize 6.2b to make that determination of what happens for the option price. And then with respect to 6.2b, there was an argument made just now that, well, you could just sell the parking lot. Well, no, you can't. Okay, it's like saying you could just sell half the building, right? You just can't do that. And I don't believe that argument was really ferreted out below or in the briefs before the court.
By the way, why can't you sell half the building? That's what a condominium project is.
Well, this is an apartment building, Your Honor, and they're not singly owned units like you would have in a condominium. It's a partner.
You can convert it. You can sell the upper stories to one company and the lower stories to another. I don't think it's impossible. You may say it shouldn't affect our reading of the contract, but I don't see why you say it's impossible.
I apologize, but impossible is probably the wrong word to use, but under the facts and circumstances and the ownership structure here, you wouldn't be able to do it. Yes, I do acknowledge that there could be a set of circumstances that you could ferret out to make that happen, but under the option here, we're supposed to look at the property, we're supposed to appraise the fair market.
A lot of lawyers devote their careers to making things like that happen.
I apologize to them. I meant no disrespect. With respect to section 6.3c, that's a savings clause. And as the district court recognized, if we were to interpret the agreement the way that the appellant is, it would result in a defect. And 6.3c would then step in to cure that to ensure there's a 90-10 distribution if we're going to be in that setting under 6.3, which we're not even there. Relative to the TDC case out of Massachusetts, I just respectfully suggest that counsel's wrong. They have noted in their papers that I was involved in that case. I am, and I still remain involved representing that client out in Massachusetts. The issue before the TDC court was not how do you determine an option price. The issue before the TDC court was how do we determine a purchase price under section 42I7 minimum purchase price pursuant to which a nonprofit can buy a property at the end of the compliance period if they have that right for debt plus taxes. It's affectionately called a $1 over debt ROFR. The argument before the court there was the phrase attributable to such sale. So under section 42I7, if they have taxes attributable to the sale, they need to be included in the purchase price. Our clients were arguing that there is a break in the causation because you have, in this instance here, full circle, for example, you have an option price. We have a sale. It triggers a subsequent event, which is a dissolution and liquidation of the remaining assets of the partnership. And then the partnership will eventually dissolve and liquidate. We were arguing in TDC that that distinction breaks the chain of causation such that taxes that would otherwise be due to the investor at exit from the partnership should not be included in the minimum purchase price. Unfortunately, the Massachusetts Supreme Judicial Court disagreed with us. But that did not have anything to do with determining an option price, and the issue before the court was not even whether or not a sale is separate and distinct from the events that would later trigger the dissolution and liquidation. And with that, Your Honors, I don't have anything else other than to close that every court so far that has looked at these issues has made the similar determination as the district court did below, and we respectfully request that you affirm. Thank you.
Thank you, counsel. Mr. Pettit, anything further?
Yes, just very briefly, Your Honor. So first, this is an issue of first impression because none of the other cases dealt with a partnership agreement that had the language that this partnership agreement has, and we explain in our papers how they're different. I also wanted to address the claim that because this is a hypothetical sale that somehow the 6.3b doesn't kick in. What the parties bargained for was that the limited partner would receive the amount that they would receive if there was an actual sale. So what they bargained for was not if there was a hypothetical sale. 7.4J says what they would receive if there was a sale. So this distinction between hypothetical and actual is not important. And then the last thing is on the defect. The defect of section 6.3c, it explains exactly how that defect is to be cured, which is something the general partner needs to do. Allocating losses.
Thank you, counsel.
Thank you.
The case is taken under advisement. Metzler against Loyola University Chicago is on for argument next. Mr. Serlich.
Good morning, Your Honors. May it please the Court. Jonathan Serlich on behalf of the appellant, Matthew Metzler. In granting Loyola's motion for summary judgment, the District Court erred by failing to apply this Court's Title IX precedent and by failing to properly apply well-established summary judgment rules. In Dovey v. Purdue, this Court did away with doctrinal tests such as erroneous outcome, selective enforcement, deliberate indifference, and archaic assumptions, and stated that, quote, all these categories simply describe ways in which a plaintiff might show that sex was a motivating factor in the university's decision. Not the, but a motivating factor. Purdue held, and subsequent Seventh Circuit cases confirmed, that one of the ways a plaintiff like Metzler can take his case to a jury is by combining evidence of pressure on a university to, quote, signal a commitment to cracking down on campus sexual assault, with facts from his specific case that create an inference that Loyola treated him differently because of his sex. Those
Mr.
facts.
Serlich, may I interrupt? What are the very best indications that any errors or irregularities were tied to gender bias rather than negligence or incompetence? To me, it seems like a somewhat different situation from the circumstances in, Doe versus Purdue University, where there really were some very, very serious indications of possible bias.
Well, I think here there are extremely significant indications of bias, and I think the strongest evidence is, there's several strong pieces of evidence, but you can't divorce what happened in the case and Mr. Love's omission of the key piece of evidence from the case. You can't divorce that from the pressure on him to signal a crackdown on campus sexual assault. And that would let a reasonable jury conclude that it wasn't just negligence, it wasn't an oversight, but there was some other motivational factor. I mean, Loyola doesn't even argue that it was negligence. They don't claim that he just made an honest mistake, and all the other things were honest mistakes. The deletion of the audio recording can't be, they had in 2016 and 2017, they had 8 investigations. And in 7 of those, the audio recording of the respondent was preserved. And only 1 was the audio recording deleted, and that was Metzler's. So this case...
Why does that imply sex discrimination?
Well, it would imply sexual discrimination. There's a couple things. Number one is the pressure on Tim Love and Loyola is at the time that this is all going on.
No, I ought to be clear. You were just emphasizing that there were 8 recordings in different cases and 7 were preserved and 1 was deleted. Why was the deletion of 1 a reason to infer sex discrimination?
Your Honor,
right? Other things like the environment in which the university is deciding and outside pressure are the same across all cases. So I'm trying to figure out why in your view, the deletion of 1 out of 8 is evidence of sex discrimination?
Sure. Judge, I think you have to look at a holistic view and look at all of the evidence. And it's not just campus, it's not just the general atmosphere of pressure. Here you have specific facts of specific pressure being made on Loyola and Tim Love in particular. And Tim Love...
No, I'm not asking about the nature of the outside pressure. You're asking us to infer sex discrimination from the deletion of 1 recording out of 8. That's where you lose me. Why is that a basis?
And what I'm saying, Your Honor, is it's improper to look at each piece of evidence in isolation and say, and do exactly what the district court here and said, well, you have to show that this piece of evidence, this irregularity was as a result of sex bias, of gender. And here we have a litany of things that Tim Love did. And the inference in this case is that Tim Love, confronted with this recording and confronted with a litigation hold letter, and it mysteriously disappears, and Loyola cannot give an explanation as to why it disappeared, raises an inference that one of those reasons is an improper one, and that's gender bias. It's just like...
Why necessarily gender biased?
Well,
why not just total incompetence here?
Well, I mean, that certainly, Judge, maybe Loyola below, if the case were to go to trial, would argue
Counsel,
that...
Judge Rovner is not in that screen. The camera is actually right in front of you.
I apologize.
Thank you.
That might be a great argument for Loyola to make at trial that, hey, we didn't discriminate against Metzler based on his gender, we were just incompetent. But to date, Loyola has not made that argument. And there are so many egregious errors in this case that Loyola committed that it takes it outside of the realm.
Is it your argument then that just you lump together these errors and those errors alone, or the number of them, that's enough to create an inference?
That's one thing. And there's 2 other things I should highlight as well. There's 2 other decision makers. Brian Howes, who was on the panel, who exhibited classic gender bias. When Brian Howes he testified that he believed that Jane was, one of the reasons that he believed that Jane was telling the truth before he ever heard any testimony from either one of them, when he read the final investigative report, he said that he believed that Jane was telling the truth because he couldn't imagine that she would engage in the sex acts at issue because she was sexually inexperienced. But at the same time, Howes didn't know Matt Metzler's level of sexual experience and didn't care to ask. And to this day, he doesn't know Matt Metzler's sexual experience. And that is applying an archaic notion of gender roles, that sexually inexperienced women would never engage in oral sex, but a man, no matter what his level of sexual experience, would. And that infected this proceeding.
Why is that gender versus victim?
Well, because he didn't say victim. And with respect to victim, I think the most powerful reason that this isn't pro-victim, and maybe that is one possible explanation, but Purdue doesn't say that we have to eliminate all possible explanations. In fact, in Purdue, the Dear Colleague letter is written to explain that both men and women can be perpetrators. But they didn't say that you have to show that it's anything more in terms of gender. And requiring more, it seems to me, would require a smoking gun, like Tim Love to admit, that says, I did this because I don't like men. We're just never going to have that. More particularly, this isn't pro-victim in terms of the community procedure standards, the procedures that were applied that may be tilted toward pro-victim or against respondents. That's not this case. This is lopsided errors that only went one way. Jane presumably knew what she told Rabia Khan Harvey, that she previously said that she didn't believe that she was forced or coerced into sexual activity, but neither the board nor Metzler knew that she said that, and that's withheld from him.
One of the key factors in Purdue was the fact that the university had a significant motive namely the allegation that they were going to lose federal funds. That allegation isn't here.
Oh,
What's the significant motive
Oh,
here?
there's two, and they're both here. Number one, the university's witnesses testified they were well aware of the Office of Civil Rights, investigation list, and it was their job to stay off that list. Number two, at the time, literally at the week before this hearing, the investigation and the hearing is going on, people are protesting and picketing the university based on their handling of these Title IX cases, including all the groups that were led by females, including the Students for Reproductive Justice, and they're calling for Tim Love to be fired. In addition, I think the day before the hearing, there was a story that broke that made national news about Loyola allowing a male on the golf team to stay on campus, even though he had been accused of rape in Georgia. And here there's the individual groups that are all led by women putting pressure on the university, and Jane herself is putting pressure on Love, meeting with Love, telling she's part of a group that's offering to write a letter in support of the university. They then write that letter, and then when she finds out that Matt Metzler was still on campus, she writes an email to Tim Love reminding him, and a thinly veiled threat to say we're going to withdraw that previous support.
That seems very different than the significant financial pressure of losing all federal funds.
Well, I don't think Purdue is that limited to say it's only can be significant financial pressure on losing all federal funds. That's one. And two, this is even more case-specific pressure. This is pressure on an individual who is putting his thumb on the scale at every turn, being pressured by groups led by women with threatening his job. And that seems to me even more concrete than the possibly losing federal funding. And then one last thing is, Tim Love, his absence of the ability to give any credible explanation as to why he omitted the Con Harvey memo is itself evidence of discrimination. We asked Love why he omitted the Con Harvey note, and he couldn't provide an alternative, not even a pretextual one. It was I like to refer to it as the immaculate omission. And
Forgive me, if the decision was ultimately based on Jane's lack of consent rather than on coercion or force, why would Jane's statement to Con Harvey be important? Excluding that evidence would be harmless, wouldn't it?
Judge, this case was, first of all, Love didn't know that at the time that he excluded it. Secondly, this case from the beginning considered force and coercion. Tim Love told Matt Metzler that the case concerned force and coercion. The coach's report that Love elected to include in the final investigative report says Jane felt pressured beyond what she felt comfortable doing. That practically tracks the university's definition of coercion. So it's a complete fiction. It's frankly one that Loyola made up in response to this case because it's indefensible that Love didn't include the statement from Rabia Con Harvey that Jane did not feel like she was forced and coerced into sexual activity. And the only way they can defend this is to rewrite the record. They use, I think, the word permission 34 times in their brief. And the word permission doesn't appear anywhere, or maybe very limited times, either in the hearing or in the decision letter itself. This case always concerned force and coercion. But going back to Tim Love's lack of his ability to give an explanation, the Supreme Court in Reeves versus Sanderson said proof that a defendant's explanation is unworthy of credence is simply one form of circumstantial evidence that is probative of intentional discrimination. So not only does Love not offer that, oh no, I was just acting pro-victim, a jury can supply the motive by his absence of being able to answer the question. And I see I only have 1:40 left, so I'll reserve the rest for rebuttal.
Certainly, counsel. Mr. Land.
Good morning, Your Honor, and may it please the court, Peter Land on behalf of defendant, Appellee Loyola University Chicago. Judge Seeger's opinion and decision about summary judgment was correct. He correctly applied the 3 decisions from this court that existed at the time when he made that decision 3 years ago, and it's consistent with the 3 decisions from this court involving Title IX gender bias assessments that have come since that time. Those 3 later decisions being Southern Indiana, Indiana University, and the Gash decision. Taken together, those 6 opinions describe a standard to determine and evaluate, is there any gender bias at issue when a school evaluates a disciplinary matter and disciplines a student. First, ask the question.
I would like you to help me. Could you give us very specific examples of evidence that would be sufficient to survive summary judgment in a case like Metzler's?
So,
give us examples of, gender, what you think it would be, gender discrimination.
It's a very broad question, and all of these cases involve very specific factual circumstances, so that's a little bit challenging. But
about this case, about not all cases, this case, what would he have had to do?
If, for example, he had been asked questions during the hearing of, don't you think that women would not understand that just moving ahead with the various sexual acts you engaged in would be something they should resist, and shouldn't you have asked, because you're a man, shouldn't you have asked for permission? That could be an example. If he had evidence of specific pressure being placed on the university to lose funds that Love knew about, that the hearing panel who decided it knew about, and that they had some meeting to talk about what are we going to do about whether we're holding enough men responsible for sexual misconduct. Anything like that could potentially would be evidence that might support gender discrimination claim.
Anything else?
I'm sure I could think of, if I sat here, I think I could probably talk about that for 15 minutes, my whole time, about what different types of evidence could support.
Why don't you start? Why don't you give me 1 minute or 2 minutes? I'd be very grateful.
Okay, if one of the hearing panel members said, I don't believe that you did that, I don't believe that you asked for permission because all men approach sexual activity in the same way, and you're not describing that in the way that men do.
Okay, well, you said that one before. What's the second one?
If, for instance, like in Purdue, none of the hearing panel members had read any of the final investigative report and weren't paying attention, and still decided that they thought that he was not credible because no one who's not had sex with someone before who's a woman would ever do what Jane allegedly did. Those are just examples that come to mind, none of which are present here. I think that, the standards that have been set by this court for evaluating whether gender bias exists when there are not examples like that are gender-based specific is a pretty high bar to proving gender bias from actions that are on their face not connected to gender. The 2 examples of areas that might be considered are where there are a significant amount of procedural irregularities such that it seems that it was a proxy for gender bias. They weren't trying to actually move through the right process. We're not trying to engage with the facts of that particular case, but engaged in procedural elements that were unfair to a degree that means it's hiding gender bias. Or, as in the Purdue case, a perplexing decision on the merits, in that case making a credibility assessment without ever speaking to or hearing from the Jane in that case. So
why
that
wouldn't the failure to interview John's 2 witnesses here when you interviewed Jane's qualify under that argument?
In this instance, the investigators interviewed witnesses who knew something about the sexual misconduct itself. They interviewed Jane's witness because Jane had told her about what happened in the room. Not that she was there.
John's
but
witness was there.
John's witness was not in the room. John's witness was in the living room that was next door.
But how did they, John said he was present at the apartment.
Yes, and there was no indication that he knew anything about what actually happened in the bedroom where they were. For instance, there's no indication that John told him that. That's the example.
But those witnesses saw the two of them. They may have seen or heard something that would have been helpful to him, but he never got that opportunity. I mean, they absolutely refused. Loyola refused to allow the two male witnesses. With Loyola withheld the statement that Jane Doe did not believe she had been coerced. There was unbelievable pressure from the women's groups on campus. The recordings in this one case somehow are erased.
Maybe I could start with the last issue, the recording deletion. In the year 2016 to 2017, in 11 of the 19 cases at Loyola, recordings were deleted. It's not unusual. The policy that they had allowed for deletion and didn't require maintaining those audio recordings of interviews, and they also explained why. The policy explained that the recordings of interviews were only to be used to prepare the final investigative report, not for any purpose beyond that. That's specifically in their policy. So the fact that there are deletions of audio recordings is not itself unusual in this case, nor around that time, nor do I think it has any gender bias inference that can be drawn from it.
Why are your statistics so different from Mr. Sirleck? Mr. Sirleck says 1 out of 8. You say 11 out of 19. Are you both using the same time frame?
I don't believe he's using the same time period. I think he's just using a time period of 2000, if I heard him right, 2015 to 2016. He's previously said in briefs that I believe 4 respondent audio interviews were not maintained in that semester, that fall semester of 2016. What I'm reciting to you is a year, 2016 to 2017, in 19 cases, 11 involved deletion of audio recording. It was a matter of practice for them not to maintain them in all cases. It was part of their policy that it wasn't required for reasons that they explained. As far as the Conn-Harvey notes and the question about whether force and coercion were actually an issue in this case, I think it's worth noting that what I heard Mr. Sirleck say was that Loyola is now rewriting the record by indicating that this case did not involve deciding whether there was force or coercion. And he said something about how the decision letter didn't reference permission. The decision letter references the absence of permission for every instance where there was non-consensual sexual misconduct found that Mr. Metzler was expelled for. It's in the letter. It's in the letter's explanation of what policy definitions were being considered by the hearing board. They reviewed the consent definition. They quoted the permission section. They explained why they were analyzing it, and they explained what their decision was based on. What is not in the decision letter and was not considered are the definitions of force or coercion. Those definitions involve things like physical violence, threats, intimidation, or unreasonable pressure, the degree of pressure. There's no assessment in the decision letter of those definitions or of those concepts or of their application to this case. There's nothing saying that there wasn't pressure or there was pressure or there wasn't unreasonable pressure or there weren't threats or there wasn't intimidation. There's nothing. In the hearing itself, there are not probing questions about those questions either. Jane references when she felt pressured or when she felt like she gave in to something. But that wasn't what they were evaluating, was it unreasonable pressure or was it a threat or intimidation? The only place where this was evaluated, the only place, which is a different context, which is important to understand, is when Con Harvey was talking to Jane. When Con Harvey was talking to Jane, it was at a point where Jane had not yet decided that she wanted to initiate a complaint that would be investigated. Instead, she was saying, I'm reporting this issue, it's concerning to me. And under their policies and practices, and as Title IX's regs required at the time, Con Harvey was talking to her to determine, is there a threat of safety to others or to you? Con Harvey was the one asking the questions about the topics I was just referencing. She was asking Jane, are you feeling threatened? Are you feeling unsafe? Did he hold you down? Did he give you repeated orders or pressures or intimidation? That comes from Con Harvey's testimony in this case, that those would be the kinds of questions she was asking Jane. And the reason she was asking was to determine not whether this was something that happened, but to determine is there a safety threat risk that the university would need to proceed with an investigation even though Jane didn't want to. So Con Harvey was the one asking those questions. Based on her discussion with Jane, she wrote down her impression that Jane does not feel that she was forced and coerced. That was never an issue that the hearing panel evaluated, and it's in every document that they generated that you can find that they focused on their decision on permission and not on coercion or force. So the reason that matters is that Jane never said anything inconsistent with the idea that she wasn't forced or coerced. She did talk to a coach who reported that she felt pressured. She did talk about giving in. But that's not necessarily the same thing as unreasonable pressure or of threats or of intimidation. And the hearing board evaluated whether there was permission, whether she agreed to do certain things. And what they found was that there were several things that that Mr. Metzler just proceeded with. He didn't ask. He just, including touching, and excuse me for the language, but touching her clitoris with his hand, rubbing her clitoris with his penis. Examples where there was no conversation about this, he just did it. There wasn't any question about pressuring her at the time to do that or pushing her to do that, he just did it. And that's what the board was evaluating, and that's how they described their evaluation in deposition testimony as well, which is entirely consistent with the decision letter. So the idea that there's a rewriting of the record by Loyola to avoid a gender bias inference from not producing the Con Harvey notes elevates the Con Harvey notes to something they're not. It was a mistake. They should have provided those notes, as they would provide any notes of anyone speaking to a complainant at any point in time. But as Chair of the Board Landis testified, those notes are consistent with what Jane said in the hearing. They're not inconsistent. So it's not some material omission that creates a gender bias inference because the whole case would have changed had those notes been part of the record. I guess I would speak a little bit about the pressure question and the nature of the pressure. We say this in our briefs, but I think it's important to note that the question about firing Tim Love, the pressure that was being applied publicly about that, had to do with him losing a case or not proceeding with a case administratively within their office. It was not about how they weren't finding men responsible, and they needed to, for sexual misconduct. And there is case law cited in our briefs about how the kind of pressure that leads to an inference of gender bias includes decision makers knowing that there's pressure to find men responsible and then caving to that pressure. I believe in our prior oral argument in front of this panel, there was an assessment or thought about what you need is pressure that involves the administration or the university caving. There's no evidence of any caving. There's no evidence that Landis or any other members of the hearing panel or the appellate officer even knew about that pressure, much less that Love tried to influence their decision. Thank you.
Thank you, Mr. Land. Anything further, Mr. Sherlock?
Yes, with all respect to my colleague, he gave a great closing argument where he's asking you to draw all the facts in the light most favorable to Loyola, and all the inferences from those facts in the light most favorable from Loyola. And that you can't do on summary judgment. In the decision letter, whether force or coercion is an issue, let me just read the decision letter. Quote, the presence or lack of coercion is a foundational component of determining whether consent was present for a sexual interaction. And now they want to stand up here and say that's not a fact issue. There's other things in the decision letter. They find that Metzler physically forced, they use the word forced, Jane's hand onto Mr. Metzler's genitalia. The discussion of sexual penetration, again, not to be graphic, but these acts, some of them only could have occurred without consent if there were force or pressure. For example, Jane touching herself. Not Matt Metzler touching Jane, but Jane touching herself and Jane performing oral sex on John. And more fundamentally, Tim Love believed this case concerned force and coercion, and yet he didn't put the statement in the final investigation report. Lastly, Mr. Love at the beginning, in answer to Judge Robner's questions about, they seem to indicate that we have to have a smoking gun, that we have to have a confession, and that's just not the law. Secondly, with respect to the discussion of the Purdue case, that is this case. Jessica Landis believed Jane before, used her as the benchmark for counsel. Thank you.
The case is taken under advisement. Our final case of the morning is Minocqua Brewing Company against Hess. Mr. Melms.
Yes, Your Honor. I apologize. This is my first time here. If it may please the court, my name is Frederick Melms. I'm here representing the Minocqua Brewing Company and Kirk Bangstad. This was a fairly straightforward preliminary injunction in front of the Western District of Wisconsin. But unfortunately, in their decision, they used the wrong legal standard in denying our preliminary injunction. Yes, I'll be addressing 3 points here. The first, obviously, the causation standard that the district court got incorrect. Yes, the correct standard, and then just the preliminary injunction standards. Obviously, as this court's, I'm sure, well aware, a First Amendment claim requires the plaintiff to prevail on to demonstrate that their activities were protected under the First Amendment. Their protective activities were a but-for cause of defendant's conduct, and they suffered the actual deprivation because of that. Now, if we look kind of deeper into this standard, what we see is that as an initial showing, a plaintiff really only has to demonstrate that the sort of animus or the retaliatory intent for a First Amendment retaliation claim was a motivating factor in the deprivation, and in the decision itself, the district court seemed to require that it was the only factor. Specifically, they used the language because of the protected speech, the deprivation occurred in denying the preliminary injunction. That's the incorrect standard under the case law cited. Instead, we just needed to show it was a motivating factor, and I think the record makes it pretty clear that it was a motivating factor. When this court looks at the record, they're going to see first there was an email from Brian Desmond to Corporation Counsel for Oneida County and the head of the zoning department discussing what they were going to do.
What's your strongest argument here that your client's speech was a motivating factor for the committee's decision?
So I think it starts with the email between Brian Desmond, Carl Jenrich, and Michael Fugel.
But that wasn't with anybody on the committee. You've
So,
identified statements and conduct by officials other than members of the committee?
So if we look specifically to committee actions, I think we see a couple of issues. The first is that there's really kind of just been very clear disparate treatment of the Minocqua Brewing Company and Kirk Bangstad. The length of zoning applications has been significantly longer for them than for others. The hearings have been more onerous, or more really. There's been a lot of aggression from the board against these two.
But what's the link with the speech?
So I think if we look to the link with the speech, when you look specifically into the briefing, what I think you see is that the board talks a lot about Mr. Bangstad's Facebook posts that are directly critical of the board and critical of themselves. And then when you pair that with the very clear disparate treatment, which I think is most obvious with the parking permit exemptions that were granted to every business within a mile of Mr. Bangstad's but his. It was like 174 over 2 years. He could get 3. I think you see that there is that connection there. There's very
But
clearly.
can we use those other businesses as appropriate comparables here, given that they didn't have the permit violations that your client did?
So the parking issues actually started well before the permit violations. The parking issues go back to the original attempts at permitting. So they go back to 2021 or 2022 when the permitting process still initially started with the administrative review permit. So those.
And by the way, you don't dispute that your client continued to operate outdoors in 24 and 25
No,
without
certainly
the
not.
appropriate permits?
We would not dispute that he operated outdoors in 2024 and 2025.
Without the appropriate permits?
Without what a night account. Yes, John.
Okay.
Sir. Certainly.
You argue in the brief that the committee chair's statement conceded that compliance matters could be addressed through permitting conditions.
Oh.
And so the stated reasons for the denial were a pretext for First Amendment retaliation. But was the committee able to get the brewery to comply by imposing permitting conditions?
So at the final hearing, Mr. Bangstad had completed all of the permitting conditions to the best of my knowledge, and they were unable to point to anything he had not at that point completed. There was some question about some drainage, but no one was able to say that he had not completed the drainage or that the drainage wasn't appropriate. We had submitted a letter from an engineer saying the drainage was just fine and everything else had been completed. So at the point that the permit was denied, with everything they wanted having been completed, at least to the best of my knowledge, I think that you have to start looking for other reasons why there was this denial. And as we kind of go through the history of this dispute, and we've been in front of the federal court now several times, I think the only really clear answer to that is that it's retaliatory for either his speech generally, his criticism of these specific elected officials, or his suits against or his prior suits against the county. And all of those are protected by the First Amendment, making the retaliation unconstitutional, and would mean that he will prevail on the merits of the final claim, and the preliminary hearing should have been granted, or at least we demonstrated that it was a motivating factor in the denial of the conditional use permit. So moving on from, I guess, that point in specific to just the preliminary injunction standard in general, I think it's very clear that this is a First Amendment issue. There should be no question as to whether or not, if this is retaliation, there is irreparable harm here, and it should have been, Mr. Bangstad should have prepared.
It seems like the court, though, in ruling, in denying the motion really focused on likelihood of success on the merits.
Certainly, Your Honor. Yes, that was where that was certainly where the bulk of the decision was. So I would just reserve the rest of my time for rebuttal.
Certainly, Mr. Mills. Mr. Jones.
Thank you. Good morning, and may it please the court. For over 2 years, Minocqua Brewing Company and Mr. Bankstead continuously violated the Oneida County zoning ordinance and a conditional use permit that the county had granted them under the ordinance. That history of noncompliance led to my clients, the members of the Oneida County Planning and Development Committee, to deny a new identical conditional use permit for the appellants earlier this summer. The district court did not abuse its discretion in denying the appellants a preliminary injunction that would have required the county to grant them that permit. To put a
Tell you what one of my concerns in this case is, please. It's the extent to which the brewery is being punished on the basis of past behavior. I mean, perhaps this is not so much a First Amendment issue, but rather a due process issue. Suppose Mr. Bankstead decided to reform his behavior and become fully compliant with all state and local requirements to the letter. Is he forever banished from getting a permit in Minocqua based on past rather than present violations?
Well, I think an important point in that respect, Your Honor, is that when Minocqua Brewing and Mr. Bankstead went before the committee in June of this year seeking a new permit, not only did the committee have before it this essentially 2-year plus history of non-compliance with prior permits, both the prior administrative review permit and the prior conditional use permit, but it also had before it Mr. Bankstead's current, then ongoing violation of the zoning ordinance insofar as he had been open all summer, was open the day of the hearing in violation of the ordinance because he didn't have a permit. And
would you try and answer the hypothetical question as it is presented? I have to tell you, I knew you were going to answer the question the way you did. So if you could just, is he ever going to be able to get permits from this group?
I'm reluctant to speculate on what permit application he will present to the committee and what circumstances would go along with that permit application. But no, as a general proposition, there's no permanent bar. But the committee, again, was considering a situation where someone was in front of them asking for a permit who that very day was violating the ordinance by being open and had publicly stated, I don't care what you do, committee, I will continue to remain open even if you don't give me a permit. That is, he's representing to the committee, I will continue to violate the ordinance. That was the basis, along with the past history, for the committee's decision to deny the permit, and we would submit respectfully that that is a legitimate non-retaliatory reason for denying the permit.
Are there other businesses that are allowed to operate without permits?
There's nothing in the record as to other businesses who might be considered to be substantially or similarly situated who have been allowed to operate without permits, have been allowed to operate in substantial non-compliance with permits, let alone for an extended period of time, like the record reflects here with the appellants. Mr. Melms, in response to your question, Your Honor, said no, there is no dispute here that he was open in violation of his permit in 2020-24 and he's been open in violation of the ordinance because he doesn't have a permit in 2025. There's nothing in the record to suggest or to allow for an inference that there are other businesses that are similarly situated.
Are there other businesses, I don't want you to put labels on it are there other businesses that are allowed to operate without getting the required permits? Don't put the similarly situated, because there's a suggestion from the other side that they are being punished here and you let other businesses continue operating even if they don't have the requisite permits.
I don't think there's anything in the record to that effect.
Okay.
I don't think there's a factual basis for the district court to have drawn that conclusion or for the appellants to make that representation.
What did the corporation counsel mean when he or she said that the county officials should be alert to Bankstead's social media posts so that, quote, you can determine what priority to give to the 9.78 rewrite? What does that mean?
The reference in that email, 9.78, is a reference to a particular provision in the zoning code relating to signs. And I believe at the time the county was in the process of considering whether or not to rewrite its sign ordinance. So it was simply a reference to the fact that this may be relevant to your consideration of that sign ordinance.
Is there an ordinance that prohibits the display of political signs by business establishments? In other words, on what basis did the county send the brewing company a letter demanding that it remove a political sign?
The letter was sent, and this was in the fall of 2020, by the zoning administrator, not a member of the committee that's the defendant in this action. And he was simply acting on the understanding that that particular sign, as was the case with other signs he'd written a letter about, was too large under the ordinance. Mr. Bankstead.
So it had nothing to do with the political view that the sign was promoting?
The record, and this is by way of an affidavit from the zoning administrator, was that that was a letter written based on the sign of the size of the sign, and he had written other such letters regardless of the political affiliation of that sign. And that was the end of that. There's nothing about any sort of further enforcement action or attempt at enforcement by the zoning administrator or the county writ large, including this committee. And that particular piece of evidence, this was cited by Mr. Melms to the court, that letter about the sign, the former corporation counsel's email, that's from 2020, early 2021. Thereafter, this committee granted the appellants a conditional use permit. I may not get the phrasing right, but that's a significant intervening event. And I think that's important in terms of assessing whether some of those early disputes is relevant in considering the causation element. And I think the district court certainly viewed it that way. In the short time I have left, the issue that's front and center in the appellant's submissions to this court is about whether or not the district court got the causation element correct. And they point to two parts of
whether
the district
court got it correct or whether it abused its discretion.
Well, they make the point that the district court allegedly made an error of law. And I take them to argue that constitutes an abuse of discretion by the district court. I don't think the district court got the law wrong. he summarized in a general way that there's a causation element and that they're required to prove cause. And any assertion by the appellants in their briefs that but-for cause isn't the standard, I think, is incorrect under the law. Nieves, this court's decision in Gross v. Town of Cicero, this court's decision in Kidwell v. Eisenhower, all talk about but-for cause. The district court then went on to correctly apply that standard using the burden shifting analysis of Mount Healthy, and ultimately, I would say, reached the correct decision, and certainly not one that is an abuse of the district court's discretion.
Thank you, counsel. Anything further, Mr. Melms?
Yes, Your Honor. I would just like to address the issue of the intervening cause that Mr. Jones raised. I think, well, it is certainly true that that the Macro Brewing Company and Kirk Bankstead were granted a conditional use permit in 2023. I think the conditional use permit was problematic, and it was intentionally so. If you look into the record, what you'll see is that the conditional use permit placed a lot of gave a lot of power over the situation to the town of Minocqua, so much so that it resulted in 2 more suits, or another suit in the Western District of Wisconsin for Mr. Bangstead and the Minocqua Brewing Company to be allowed to use a driveway that had been used by the prior business at that location without incident for nearly 20 years. I think that it's fairly clear that Oneida County was aware of the power they were giving the town of Minocqua and the fact that they were inserting what is effectively a poison pill into that conditional use permit. Now, Mr. Bankstead certainly accepted the conditional use permit because after a couple of years of fighting just to, try and sell beer in a tourist town, he took it. And
is he still operating today?
He is. Maybe today. I don't know if they're operating during the week right now. Certainly they were over the weekend.
Over the summer, they operated over the weekend?
Yes. Yeah, they would have, if this were August, they'd be operating today. I don't know if they're operating on a Monday in September, though.
Whatever he received originally about the sign, did it say it's the size of the sign?
It was about the size of the sign, Your Honor, but what I think is most interesting is that while the county claims that there was other enforcement, what they don't point to are any of the equally large Trump signs that were throughout Oneida County at the same time that did not receive any enforcement action. So I guess they can...
It was only Biden signs that...
Mr. Bangstead's sign was the only one we were aware of that was targeted.
And was his the only Biden sign in town?
Certainly in downtown Minocqua, I believe it was, yes.
Thank you.
Thank you.
Thank you very much. The case is taken under advisement, and the court will be in recess until 2 o'clock.